Imagine walking through a park on a beautiful afternoon when suddenly you witness something deeply troubling, something that shakes your faith in human decency and social order, something that makes you question the very foundation of the legal system designed to protect us all. And that something is a crime. But here is the critical question that most people never truly contemplate. What exactly makes an action a crime? Is it simply breaking a rule? Is it harming another person? Is it violating society's moral standards? The answer, surprisingly, is far more complex and precisely defined than most people realize. And understanding the essential elements of crime is not merely an academic exercise for lawyers and judges, but rather a fundamental necessity for every citizen living in a civilized society who wishes to understand how justice truly works. Today, we are going to embark on a deep, comprehensive journey into the heart of criminal law, exploring the intricate architecture that defines what a crime really is, examining the essential building blocks that must be present for any action to be prosecuted as a criminal offense, and discovering through real-world examples exactly how these elements work together to form the foundation of our entire criminal justice system. This is a topic that affects every single person in society because whether you realize it or not, understanding crime and its essential elements gives you the power to understand your rights, to recognize injustice, to comprehend the news you see every day, and most importantly, to make informed decisions about your own conduct and the conduct of those around you. Let us begin by establishing a clear, legally sound definition of what crime actually means in the context of modern legal systems. A crime is fundamentally defined as an act or omission that violates a statute, rule, or regulation established by government authority, and which, upon conviction, results in punitive consequences imposed by the state, such as imprisonment, fines, probation, or other legally mandated penalties. This definition is crucial because it immediately distinguishes criminal law from other areas of law, such as civil law, where disputes between individuals are resolved and damages are paid, or administrative law, where agencies enforce regulatory compliance. The key differentiator is that crimes are offenses against society as a whole, not merely against an individual victim, which is why criminal cases are brought by the government and are styled as the state or country against the accused person. Consider for a moment the practical implications of this distinction. If someone breaches a contract with you, that is a civil matter, and you must sue them to recover damages. But if someone assaults you or steals from you, that is a criminal matter, and the government prosecutes them on behalf of all citizens, recognizing that their conduct harms not just you as an individual, but society's collective interest in peace, safety, and security. Now that we have defined crime in its broadest sense, we must understand the essential elements that must be present for any criminal offense to exist, and these elements are absolutely foundational to the criminal justice system. The first, and perhaps most fundamental essential element, is the actus reus, a Latin term meaning the guilty act or the physical conduct that constitutes the crime. The actus reus is the actual criminal act or conduct itself, and it is essential because it means criminal liability cannot be imposed for mere thoughts, intentions, or desires, no matter how evil or dangerous they might be. This is a cornerstone principle of criminal law, rooted in the belief that people should only be punished for actions they actually commit, not for what they think or feel. To illustrate this principle clearly, imagine a person who thinks about robbing a bank, plans every detail of the robbery in their mind, and even fantasizes about the money they will steal, but never actually attempts to rob the bank. Despite having terrible intentions and a detailed mental plan, this person cannot be prosecuted for robbery because the essential element of actus reus is missing. They never actually performed the criminal act. However, if that same person takes one step toward the bank, the principles of attempt liability can come into play, but that is a different discussion. The actus reus can take many forms. It can be a positive act, such as assaulting someone, stealing property, burning down a house, or selling illegal drugs. Or it can be a failure to act, what lawyers call an omission, such as a parent failing to feed a child leading to harm, a driver failing to stop at a red light causing an accident, or a person failing to report a crime when legally required to do so. This distinction between commission through action and commission through omission is vitally important because it expands our understanding of what can constitute criminal conduct. The second essential element is the mens rea, another Latin term that translates to the guilty mind or criminal intent, and this element addresses the mental state and intention of the person committing the crime. While actus reus is about what the person did, mens rea is about what the person was thinking when they did it, and this distinction is profoundly important in criminal law. Mens rea generally encompasses 4 primary levels of mental culpability that courts and legislatures recognize, and these levels range from the highest degree of intent to the lowest. The highest level is specific intent or purpose, which means the defendant acted with the conscious objective to cause a specific result or to engage in specific conduct. For example, in a theft case, the mens rea requires that the defendant specifically intended to permanently deprive the owner of their property. Stealing something accidentally or intending to return it later would negate the mens rea for theft. The second level is knowledge, where the defendant acts with awareness that their conduct will likely cause a particular result or that a particular circumstance exists. Consider a person selling water knowing that the buyer believes it is bottled water for drinking, while the seller knows it is contaminated. This shows knowledge that the product does not meet representations. The third level is recklessness, which involves a substantial and unjustifiable risk that a harmful result will occur, and the defendant consciously disregards that substantial risk. A person who speeds excessively through a residential neighborhood where children play exhibits recklessness because they consciously disregard the substantial risk that their excessive speed might result in harm or death.